When discussing ADA compliance and website accessibility litigation, website owners commonly use the terms shakedown and troll. So let's talk about those two terms. In this context, shakedown basically means illegal or unethical practices where a lawyer exerts pressure, i.e., a lawsuit, to get money and basically a settlement. And then a troll in this context would refer to a lawyer who files frivolous or insincere lawsuits. So on the whiteboard with me, I have several bullet points that I want you to mull over as you think about these two terms. First, the DOJ stance is that the ADA does apply to websites. This is an unofficial stance, right? They haven't yet issued regulation, but we know regulation is forthcoming. Also, we have 5 years of experience. We have 5 years of litigation to go off of, right? So if it's mysterious, if you're unsure, you really shouldn't be, because this has been something where the attention garnered and the discussion around ADA website compliance has been significant at this point. Also, another bullet point, we do have several instances of one plaintiff with dozens of lawsuits filed. So this could go to that insincere point. Another bullet point, some lawyers have been sanctioned for their activity in website accessibility litigation. Another point, how do people with disabilities gain access, right? We know this is an area of litigation and there's an industry around it, but getting away from all that, if you're a website owner, how do you ensure that someone has access to your website if they have a disability? What steps have been taken? And then furthermore, the last bullet point I have is, what efforts have you actually made? So it's one thing to talk about the litigation, how unfair it may be, but what have you done to prevent that litigation? What have you done to make your website accessible? So now this all leads to, what can you do, right? We know the problem. We know the legal mire that exists, right? We know this ongoing ugliness where we have litigation and plaintiffs' lawyers filing lawsuits. There are literally thousands that are filed every year. And then there are multiples of that are informal demand letters that are sent out. But what can we do to prevent that altogether? Well, if you're concerned with the troll aspect, right, then why not preempt the troll, right? And I've drawn a line from troll to this box I've drawn. Why not just resolve the accessibility issues that plaintiffs' lawyers are looking for? Wouldn't this be convenient, right? If we knew what exactly they were looking for on our website, and then we knew how to resolve those issues. Well, we do. That is why I created the ADA compliance course, to tell website owners exactly what to do so that they don't even have to worry about litigation. It doesn't matter whether it's a shakedown. It doesn't matter whether the lawyer is a troll. You can argue that if you want to, but that's not furthering anything. That's not resolving anything so that you can move forward. Why not just stay away from litigation altogether rather than having it be something that looms over you, right? Resolve the issues that plaintiffs' lawyers are looking for. If you do that, it is very unlikely that you would ever be sued. So you'd never be involved in this to begin with. Now, I understand website accessibility may have been something that caught you off guard. Maybe you didn't even know that a website could be made accessible. I didn't in 2016. I had never even contemplated the idea of that. But when it comes to your attention and you know that it's something that needs to be addressed, why not just address it? If you address it, then this is something you can get ahead of, and you don't even have to, you don't have to worry about the forthcoming regulation because you've already taken care of it. So beyond just resolving the issues that plaintiffs' lawyers look for, there are more accessibility considerations. So what would you do? You would look to the Web Content Accessibility Guidelines. These are technical standards that set out how to make a website accessible. So if you know what these technical standards are, you can make your website completely accessible. So not just you're not just addressing what the plaintiff's lawyers are looking for, right? It's not just about the plaintiffs. You can also make your website so where you're taking in all of these different considerations to ensure an optimal experience. This is not only going to help with accessibility, it's also going to help with usability. So you really stand to gain when you start implementing these measures. It's really, really helpful. And so this is a way to take this into really a discussion that's just getting bogged down, right? Like if you're just continually mired in talking about shakedowns and trolls, rather than doing this, let's just turn this into, okay, well, but how do we avoid this altogether? What are they looking for? What is it that I need to be concerned about? Okay, then let's just go ahead and fix that, right? Because we know the DOJ states that you need to make your website ADA compliant. And now the DOJ, what they have said is that you have flexibility in how you make your website ADA compliant as long as you do. But soon, in the coming years, it won't be too long, there will be actual regulation that sets out how to make your website ADA compliant. But for the time being, we already know what we need to do. And so I told you, we can resolve the issues that plaintiffs' lawyers are looking for, and then we can work to full WCAG conformance. This is not an impossibility. This is not too vague. It's not too ambiguous. It is something that can be done. I have courses that address this specifically. The ADA compliance course tells you exactly what to do to prevent litigation. The WCAG course fully explains the Web Content Accessibility Guidelines in plain English. This way, we can work to a resolution rather than worrying about the context of this litigation, right? Yes, I will agree that these lawsuits came on, and especially for website owners early on, this was just out of nowhere. And the DOJ didn't provide much help. There wasn't much notice, but all of a sudden, private litigation became an industry of it in and of itself. But that industry is now established. So we know what we are dealing with. And now we know what to do. It's no. This is something this is not guesswork, right? So if you are worried about litigation, if you want to preempt it, all you have to do is take action, and you take intelligent action. Make sure that you are resolving the issues that plaintiffs' lawyers are looking for, are commonly looking for. And we know this because I have looked through these complaints filed in court. I know exactly what plaintiffs' lawyers are looking for. If you take care of these issues, it is very unlikely that you would be sued. Further, if we work towards WCAG conformance, again, as you're working towards conformance, and you must make sure to prioritize, right? Prioritize the issues that are claimed in litigation, because those will reduce our risk as we go. So there's a strategic component to this, but the strategic component is known, right? You have to prioritize these issues, but then you want to work towards full conformance. It's definitely doable. I have courses on it. This is all to address this scenario where we have an industry around litigation. Preempt it, avoid it. Just take yourself out of the discussion.